All right. Mr. Stevens, can you hear me?
I can hear you.
And Mr. Reichert, can you hear me? Mr. Reichert, can you hear me? He's having some problems. Ms. Steele, can you hear me?
Yes, I can, Your Honor.
Mr. Reichert, can you hear us?
You can, Judge.
Okay. We'll be on the record in Butte County case CR 12-19-639, State of Idaho versus Amanda Steele. Ms. Steele is appearing by video. She is represented by Mr. Shane Reichert, who's appearing by video. The state is represented by Butte County Prosecuting Attorney Steve Stevens, who's appearing by video as well. I'll advise and remind the parties that this matter is being live streamed. At our last conference, the court indicated some concerns with the amended information and what constituted the felony. And this court's concerned about being able to accept a guilty plea on without having a factual basis for great bodily harm. Asked the parties to address that issue. The court did some research as well, and Ms. Steele, I contacted Mr. Stevens and Mr. Reichert, I think 2 days after that hearing, regarding a case that I was provided and found. And there was a couple of cases that deal with this, and I reviewed that with them. The primary case is State versus Coffin, and I just want to review that with the parties here today. But before I do so, Mr. Reichert, what's the current posture of the case?
Your Honor, after our status conference and then reviewing these cases, Mr. Stevens and I have discussed the matter, and the intent is to enter the plea agreement as submitted to the court.
Okay, so let me just make it, and Mr. Stevens, is that correct?
That is correct, Your Honor. And there is an amended prosecuting attorney's information that was filed, actually lodged, not filed. Wouldn't be filed until the court orders the amendment, or orders, signs an order and files an order allowing the amendment. And I think there may be a previous proposed amended information that would be withdrawn.
Okay, and I saw that amended complaint today. So let me go through and kind of explain the position. So at our last hearing, the court was right in the respect that the then amended complaint didn't allege a felony offense, but was not correct in its assertion that it needed to be able to make a factual or establish a factual basis for the guilty plea. And the court is looking at State versus Coffin, which is 104, Idaho 543. I'm simply going to read a portion of that case. In that case, the defendant had entered a plea of guilty to the crime of burglary. Apparently at that time, the crime of burglary required as an element of the offense that the crime occurred during the night. On the appeal, the defendant was asserting that the court did not establish a sufficient factual basis for the crimes charged, because he was asserting that the facts of the crime were that he broke into these cabins during the day. So I'm just going to read from the case. Starting on page 545, instead he challenges that the trial court erred in accepting his pleas of guilty to first-degree burglary charges without first establishing a sufficient factual basis for the crimes charged. The defendant accurately notes in his brief on appeal that there is currently no requirement in Idaho that the trial court must establish a factual basis prior to accepting a guilty plea. Further, this court has previously stated that a valid guilty plea, voluntarily and understandingly given, is a judicial admission of all the facts charged by the indictment or information. A defendant, by entering a valid guilty plea, waives all non-jurisdictional defects and defenses, whether constitutional or statutory. Finally, a valid plea of guilty is conclusive as to guilt and obviates the necessity of the prosecution going forward with the evidence. Nevertheless, the defendant alleges that the facts establish that he entered the cabins in the daytime, and therefore that the district court erred in accepting his pleas of guilty to first-degree burglary when the facts failed to support those charges. We disagree. The record shows that the information charging the defendant with first-degree burglary were read to the defendant at his arraignment. The informations contain the elements of first-degree burglary, including the allegation that the burglaries occurred during the nighttime. Before accepting the pleas of guilty, the district court interrogated the defendant regarding his waiver of rights, his understanding of the English language, his education, the voluntariness of his pleas, and the plea bargaining arrangement, and informed him of the maximum penalties that could be imposed on each count. The court accepted defendant's pleas of guilty only when convinced that they were freely and voluntarily given. The defendant did not argue or otherwise inform the court at the arraignment hearing that he claimed to have entered the cabins in the daytime, nor does the record disclose that the court was aware of the alleged factual discrepancy at that stage of the proceedings. The court did, however, expressly ask the defendant whether there was any reason other than the plea bargain why the defendant was pleading guilty to these serious offenses. The following dialogue ensued. Mr. Coffin: yes, sir, I understand your question. Pleading guilty because I am guilty, I guess, sir. The court: and I suppose you feel that even if you plead not guilty, the chances of the state proving its case is pretty good. Is that a fair statement? Mr. Coffin: yes, sir. Thus, not only did the defendant's pleas of guilty to first-degree burglary charges constitute a tacit admission of the facts alleged in the information, but prior to the court's acceptance of the guilty pleas, the defendant expressly admitted that he was guilty of the charges. Therefore, given the defendant's voluntary entry of pleas of guilty and express admissions of guilt to the first-degree burglary charges, we hold that the court was not obliged to establish a further factual basis for the charges, and that the court did not err at this stage of the proceeding in accepting the defendant's pleas of guilty to first-degree burglary charges. The defendant's allegations that he entered the cabins during the daytime and inferentially that he was innocent of first-degree burglary came to the court's attention at sentencing hearing held on September 8th, 1980. The district court registered its concerns that the defendant pleaded guilty to first-degree burglary when he claimed that to have entered the cabins in the daytime. The court inquired as to whether the defendant had pleaded voluntarily and whether he was aware of the differences in sentences that could be imposed upon first and second-degree burglary convictions. Defendant affirmatively answered both inquiries. The court then advised the defendant to think carefully about his pleas and to discuss the matter with his attorney, and further advised the defendant that the court would allow him the opportunity to withdraw his pleas of guilty to first-degree burglary. The district court then recessed. The court reconvened at approximately 3 p.m. on September 9th, 1980. At that time, the court asked the defendant whether he wanted to continue with or withdraw his guilty pleas. The defendant stated that he had thought about his pleas, had had time to discuss them with his attorney, and that he wished to continue with his pleas of guilty. Only after that, the defendant reaffirmed his desire to plead guilty to the charges of first-degree burglary, did the trial court enter its judgment of conviction and impose sentences thereon. The court then talks about the North Carolina versus Alford, which is the precedent for an Alford plea, where the defendants, where the court can accept a plea even when accompanied by protestations of innocence. So, having reviewed that case and the others that have cited to Coffin, it appears that the amendment, even though I've got some concerns about certain elements, as long as the plea is made knowingly and voluntarily, this court will be able to accept the plea and move forward. Now, there was a plea agreement that's entered in this case that deals with the sentencing. It's meant to be binding on the court. Paragraph 7 talks about that in the plea agreement, that the defendant would not be sentenced more than retained jurisdiction under paragraph A. Under paragraph 7B, if the pre-sentence report recommends probation, the court will not impose incarceration other than local jail time to be scheduled in the court's discretion on weekends, that she does not have custody of her minor children, and be allowed work release. C, in the event the defendant's psychosexual evaluation indicates a low risk of recidivism, the defendant shall be sentenced to a term of probation with local jail time as appropriate. D, restitution, if any, as well as a fine in the discretion of the court. E, that the sentences for both counts run concurrent. And F, the state will defer to the court on the issuance of a withheld judgment. So when I go through that, and I'm looking only at what I know about the case at this point, having not talked to Ms. Steele or reviewed any psychosexual evaluation or pre-sentence report, I do have concerns about 7B and 7C. I'm willing to move forward, however, to take the plea, order the pre-sentence report, and look at the psychosexual evaluation before I reject or accept the plea. But I want all parties to know that I have concerns about those two sections. With that, Mr. Reichert, do you need any time to talk to your clients more? Are you ready to move forward?
I believe we're ready to move forward, Judge. We've discussed these matters as well.
All right, Mr. Stevens.
Your Honor, one issue that probably just should be noted for the record in the plea agreement is the plea agreement is a Rule 11 plea agreement that's intended to be binding. However, it needs to be understood, and I think I probably should have brought this up with Mr. Reichert while we were discussing this. So there could be a note in the plea agreement, but in 7C, the court can allow whatever scheduling of incarceration if the court did in fact accept the plea agreement when the time comes for the court to make that ruling. It just needs to be understood that any kind of scheduling of local incarceration is going to be subject to the policy of the jail. And right now we've been running into issues where in the magistrate court, there are commonly where the magistrate court actually allows scheduling of jail or work release or those sorts of issues or those sorts of options. The jail's not allowing that because of the pandemic circumstances. And many jails have changed their policies and are requiring people to at least be incarcerated for the period of quarantine. And it's also affecting out of jurisdiction housing of jail. So those are all things that could happen that are not part of this plea agreement. They're not even part of the court's jurisdiction to control. And everybody needs to understand that the court can allow, any court could allow scheduling of jail or work release or something like that, but it's always going to be subject to the policy of the sheriff on how it can allow, on whether it even offers that kind of program. So I just wanted to make that clear for the record here today as well, Your Honor.
Yeah, in addition to that, and I assume you've discussed those issues, Mr. Reichert, with Ms. Steele.
Judge, we haven't discussed specifically the impact of COVID on any potential jail time. My guess is she doesn't have any inquiry. We've covered several issues in this case, but I don't think any of the parties have any control over that specific issue at this point. And I don't think that will change her position on moving forward today. I would anticipate that sentencing will be set up for 6 to 8 weeks. And hopefully we've made some progress with COVID, but obviously no one can predict the future either.
If I remember correctly, she's no longer living in Butte County as well, right?
That's correct, Your Honor.
So if there's any jail time locally that's imposed, typically they're required to do that in the county where the sentence is. But if another jail facility in a different county allows them to serve time, that can be done, but there's usually a fee associated with that as well.
Correct, Judge.
All right, Mr. Reichert, have you done all you believe that should have been done by way of investigation, discovery, and motions to suppress evidence?
Yes, Your Honor.
Have you had sufficient time to discuss this case and all of its ramifications with your client?
Yes, Your Honor.
Have you explained to her all of her rights, defenses, and possible consequences of the guilty plea?
Yes, Judge.
And given all the circumstances, do you consent to your client's plea of guilty?
I do, Judge.
All right. Ms. Steele, if you'll raise your right hand, I'll have the clerk place you under oath.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you, ma'am. You can put your hand down. Are you a citizen of the United States?
I am.
Are you on probation or parole?
No, I'm not.
Are you addicted to drugs or alcohol?
No, I'm not.
Are you currently under the influence of any drugs or alcohol?
No,
Do you have any psychological or mental health issues that could have a bearing on your case?
no,
And do you take any prescription medications?
no, I do not. Well, blood pressure medication. Sorry, Your Honor.
Okay. Other than that, anything else?
No,
Have you had sufficient time to discuss this matter and all of its ramifications with your attorney?
yes, I have.
All right. You filled out a guilty plea advisory form in this case, is that correct?
I did.
I'm going to share that on the screen with you. When you went through that document and if you had questions, were you able to ask those questions of Mr. Reichert?
Yes, I did.
And was he able to answer your questions?
Yes.
All right. You should see on your screen then the advisory form. I want to go down to the last page. Is that your signature on page 8?
It is.
And is that your signature on page 9?
Yes.
And are your answers in that document true and correct?
Yes.
Now, you've entered a plea agreement. I'm going to put that up on the screen. Did you read this document?
Yes, I did.
If you had questions about it, were you able to ask those questions of Mr. Reichert?
Yes.
And was he able to answer your questions?
Yes.
So the agreement states that you're going to plead guilty to 2 amended charges of injury to child, correct?
Yes.
Let's see. And do you understand what the maximum penalty is for each count?
Yes.
And what's the maximum penalty?
10 years and $50,000 fine.
And other than the plea agreement, if you take the plea agreement out of the binding portion, if you're pleading to 2 counts, those sentences could be run consecutive, meaning that you're looking up to 20 years and $100,000. You understand that?
Yes, I do.
And you understand I can impose the maximum penalties on each count if I refuse to accept the guilt or the plea agreement?
Yes.
All right. You're also agreeing to waive your right to appeal the judgment of conviction based upon your plea. Is that correct?
Yes.
Later on, and we'll talk about it, but you do reserve your right to appeal the sentence in this case, assuming I don't follow the plea agreement, correct?
Yes.
Is that correct?
Yes.
I should note as well that you're required to pay restitution, or I can order that you pay restitution to any victim of those two alleged counts, correct?
Yes.
And then because they're felony offenses, you'll be required to provide a DNA sample and thumbprint to the state. Do you understand that?
Yes.
In paragraph 3, you're agreeing to pay restitution to the victims of the charges, but you're also agreeing to pay restitution to any related act to this case, whether charged or uncharged. Is that correct?
Yes.
And then they're saying that restitution has to be presented or otherwise resolved by the date of sentencing. Is that correct?
Yes.
Now, have you discussed with Mr. Reichert the possible amount of restitution?
I don't think we've talked a specific amount.
Okay. Do we have an idea what that specific amount may be, Mr. Reichert?
I don't believe so, Judge. I think that information would still need to be submitted to the court, or to the state, I should say.
All right, Mr. Stevens?
There's no indication there is any restitution in this case, Your Honor. It's just a precaution in case that something does come up.
All right. Paragraph 4 states that you'll obtain a psychosexual evaluation and that you'll successfully complete any recommendations contained in that evaluation or otherwise ordered by the court. Do you understand that? Is that part of the plea agreement? Ms. Steele?
Yes, it is.
In addition, the plea agreement provides that the state will dismiss without prejudice the original count, or the count 1 in the original information charging with sexual battery of a minor child, 16 or 17. Is that correct?
Yes.
Now, it's without prejudice, and the state's indicated that they would reserve the right to refile that count in any other crimes arising out of this matter if you have a new felony sex offense conviction that occurs after November 19th of 2019. Is that correct?
Yes.
Now, this is the binding portion of the plea agreement. The parties are asking the court to sentence you to no more than retained jurisdiction. However, if the pre-sentence investigation recommends probation, the court would not impose any incarceration other than local jail time, and that jail time would be scheduled at the court's discretion on weekends that you don't have your minor children, and would be allowed work release. Is that correct?
Yes.
And you understand that I don't have control over whether there's a work release program or whether they'll allow you to simply do jail on weekends. You understand that?
I do.
All right. In addition, if your psychosexual evaluation indicates a low risk of recidivism, then it says that my discretion is even more limited in that I can only give you probation with local jail time as appropriate. And the way I read the plea agreement is that would be local jail time would be subject to the provisions of paragraph 7B as well. Is that correct?
Yes.
Mr. Reichert,
Yes, Judge.
Mr. Stevens?
Yes, Your Honor.
You're agreeing to pay restitution, if any, as well as a fine that will be at the discretion of this court. The
Yes.
sentences would be imposed concurrently, and the state will then defer to the court on the issue with a withheld judgment, which means you can ask for one, but it's still within my discretion whether I grant a withheld judgment or not. Do you understand that?
Yes.
So, on a binding plea agreement, to make sure that you understand, is what I will do is if I accept your plea today, I will order what's called a pre-sentence investigation. That report will reveal any prior criminal history that you have, and I will consider that at the time of sentencing. In addition, they will do what's called a gain-eye evaluation. That's to determine if you have any mental health or substance abuse issues, and I'll consider those reports. In addition, I will order a psychosexual evaluation, and that evaluation will be provided to me that will basically address your risk level to the community, and I will consider those reports, not only in how I sentence you, but whether I will accept the guilty plea or not. Do you understand that?
Yes.
Once I review those and we come back for sentencing, on the record in court, I will tell you if I'm going to accept it and be bound by the plea agreement or not. If I accept the plea agreement and agree to be bound by it, then the terms that we just went through, this court will follow. If, however, I determine that portions or all of the plea agreement are not appropriate, I will inform you that I'm not accepting the plea agreement, and then you'll be given two options. The first option would be is that you would have the right to withdraw your guilty plea. The original charges would most likely be reinstated at that time, and then you could proceed to jury trial. The second option would be is that you could maintain your plea of guilty to the amended charges, but with the understanding that any sentence I impose could be harsher than that contemplated by the plea agreement. Do you understand that?
Yes.
All right. Now, when I order the pre-sentence investigation, the psychosexual evaluation, you still will have your rights to remain silent in that regard, and the right to counsel during those interviews and those processes. Do you understand that?
Yes.
I believe you've already had a psychosexual evaluation, but if that's not the case, is what you do need to understand that if you don't participate in a psychosexual evaluation, just a minute, then this court would have no option other than to consider you a high risk to reoffend. Do you understand that?
Yes.
Unless there's sufficient information contained in the reports to find otherwise. Do you understand that?
Yes.
All right. Now, are you pleading guilty freely and voluntarily?
Yes, I am.
Is anyone forcing or pressuring you to plead guilty?
No.
Has anyone promised you that I would be easy on you if you pled guilty?
No.
Has anyone promised or suggested that I would place you on probation if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone offered any rewards of any kind to make you plead guilty?
No.
Is it fair to say that you're pleading guilty to these crimes of your own free will and without any pressure or influence from anyone else?
Yes.
Do you fully understand that by pleading guilty, you give up your constitutional rights to a trial by jury, your right to confront your accusers, and your privilege against self-incrimination?
Yes, I do.
Do you have any questions about your constitutional rights or what they mean?
No, I do not.
You also understand that you waive any defenses that you may have?
Yes.
All right, I'm going to put the amended information up because we've covered the penalties, but not the actual charges. Have you seen a copy of the newly amended information?
Yes.
All right. So this is the amended information, charges you with injury to child in count 1 and charges you with injury to child in count 2. Have you read that document?
Yes, I have.
All right. It was filed on June 29th, 2020. You have the right to have that information read to you here in open court, where you can waive the reading of the information.
I'll waive that right, Your Honor.
Knowing all, now, one thing that I'm going to make sure that you understand, I'm going to ask you to tell me what you did that makes you guilty of those crimes, and then we'll have some other discussion of it. Are you prepared to go forward then?
I am.
How do you plead to count 1 of injury to child, guilty or not guilty?
Guilty.
And to count 2 of injury to child, guilty or not guilty?
Guilty.
Tell me what you did that makes you guilty of each of those crimes.
I engaged in a sexual relationship with an individual under the age of 18 twice.
Okay. And that person's identified by the initial LG in the complaint on count 1. Do you know who that is?
Yes, I do.
And that child is indicated by the same initial in count 2. And you know who that person is.
I do.
All right. Count 1 occurred on or about January 28th of 2016. Is that accurate?
Yes.
And where did it occur at?
His residence,
Which county and state?
Butte County in Idaho.
Okay. And in count 2, it says it occurred on February 4th of 2016. Where did that occur at?
My residence in Butte County, Idaho.
Okay. Now, count 1 and count 2 says that you did this under circumstances likely to produce great bodily harm and willfully caused or permitted the child to suffer unjustifiable mental suffering by engaging in intercourse with him. You heard my concerns about the great bodily harm and mental suffering the last time we talked about this. So I don't know if there's any evidence that you've been provided that would prove that. But do you understand that by me accepting your guilty plea and by you pleading to that, you're agreeing that you caused great bodily harm, or that you, let me back up, that you caused the child to suffer unjustifiably and in such a manner that was likely to produce great bodily harm,
Yes.
even though there may not be sufficient evidence to support that claim, you still want to plead guilty.
Yes.
And that goes to count 2 as well.
Yes.
Court finds the defendant understands the nature of the offenses and the consequences of pleading guilty to those offenses. Court also finds there is a basis for the guilty pleas and that the guilty pleas were freely, voluntarily, and knowingly made. Therefore, the court will accept the guilty plea. The acceptance of the guilty plea, I'll just reiterate, does not mean I'm going to accept the plea agreement. I will make that determination once I receive the reports. Mr. Reichert, as far as the psychosexual evaluation, do we need to order one, or has one been prepared that you're going to submit to the court?
Well, I think it probably needs part of the order, but yes, we will submit one. I've reached out to Robert Lesota. I think the court's familiar with him. He's an approved provider. The only thing that needs to be added into that report is the polygraph that accompanies that.
Right. Has a polygraph been done at this point?
No, Judge.
Okay. So, Madam Clerk, if you'll give me a sentencing date, I'm going to order a pre-sentence investigation. I will also order the psychosexual evaluation, which will include a polygraph examination. The psychosexual evaluation that's been performed may be used. It will need to be updated, however, once the polygraph results are completed or obtained. Madam Clerk.
August 11th at 9:30.
Yes.
Judge,
Is that going to give us time to get all that done?
I don't know. Probably enough to get it done, but I do have a sentencing scheduled for that day that starts at 9 a.m. in Bannock County, and I anticipate that sentencing is actually going to take quite some time.
I'm scheduled to be back in ARCO on September 8th, assuming we're in person. If not, we'll be doing it by video. September 8th work.
That works, Judge. Thank you.
Mr. Stevens?
That's fine, Your Honor.
All right. We'll set sentencing then for September 8th. Madam Clerk, Mr. Reichert, how much time do you anticipate?
I don't think it'll be longer than a standard sentencing hearing, Judge, other than addressing any concerns the court may have.
You going to have any witnesses that you anticipate at this point?
I don't anticipate any witnesses at this point. However, if that should arise, I will definitely notify your staff.
All right. Mr. Stevens?
The same, Your Honor. At this point, we don't have any reason to think that there's going to be any impact statements or testimony at this point, but we would certainly notify the court if we think there's going to be a more lengthy sentencing hearing than we see typically.
Right. So what I'm going to do is I'll set it for 10:30, and I'll just ask my clerk not to set anything after 10:30 on that date in anticipation that we could have an hour-long sentencing, but depends. And I'll probably try and contact you a couple of weeks before to make sure that we're not going to be having anything longer than a half hour. That way, if I need to fill the rest of the time, I can.
Good, Judge.
All right, Mr. Reichert, do you have anything else today?
Not at this time, Judge. Thank you.
Mr. Stevens?
No, Your Honor. Thank you.
All right. Ms. Steele, I'm going to have the clerk give you the phone number for the pre-sentence investigation writer. You'll need to contact that individual as soon as we're done here, and let them know that you need to get the pre-sentence report started, as well as the game, and that there's a psychosexual evaluation that'll need a polygraph done. And then Mr. Reichert can help you follow up with that as well. So Madam Clerk, if you'll give her the phone number.
This is going to be Julie Morrison. And the number is 208.
Judge, sorry, can I interrupt really quick? Can we get this phone number to Miss Steele off the record? Is that possible? I'm just concerned that this is, I mean, I assume people can track it down and make contact. I just don't want to bombard this individual with potential phone calls or things of that nature that aren't relevant.
All right. So is what I'll do, Mr. Reichert, I'll simply email you the phone number.
I'll be sure to get it to her, Judge.
I'll have the clerk email the phone number to you, and then if you'll get that to Ms. Steele, and then that phone call needs to be made before 3 o'clock today.
Will do, Judge.
All right. So, Madam Clerk, I assume you have Mr. Reichert's email?
Yes.
All right. And then you'll send me the orders to sign?
Yes.
Okay. Mr. Stevens, do you have anything else then today?
No, Your Honor.
I guess I should clarify, I put on the record the coffin case, but in your research, did you have anything different that you needed to put on the record here today in regards to the plea?
Not
Your
from
Honor,
the,
I'm sorry, go ahead, Mr. Reichert.
sorry, not from the defense. I followed up with those cases and did some research backdated as well. So I agree with the court's interpretation of the law.
Mr. Stevens?
I agree with that, Your Honor. I don't see any additional issues,
Okay.
especially given the nature of the plea agreement.
All right. Anything else on Mr. Reichert?
No, Your Honor. Thank you.
All right. Ms. Steele and Mr. Reichert, Mr. Stevens, you're excused. Thank you very much.
Thank you, Judge.
All right, you can stop the live broadcast.